The State of Crypto is presented by Tron, connecting the world to the power of cryptocurrency.
All right, joining us more with legal advice on all this Kraken news is Ketsal partner and former SEC Attorney Zachary Fallon. Zachary, great to have you this morning. So Kraken is closing its U.S. staking program and will pay a $30 million fine to settle the charges, as we just learned from CoinDesk managing editor Nick Day, but they did not admit to or deny the allegations and will keep in place its international staking services. So what new limits do you think the SEC may seek to impose on the industry?
As far as new limits, I think I'm not so sure about new limits, as I would look at it as continued dogged pursuit of what they perceive to be securities laws violations in the crypto space, continued reliance on the concept of an investment contract really as a regulatory catch-all to oversee novel financial arrangements in the crypto industry, in this case, staking as a service. So again, along the lines of what Nick said, this is not a condemnation of staking writ large as a means by which people can independently validate transactions on a proof of stake blockchain. This is limited to this is a condemnation of Kraken's staking program specifically. Now, of course, it is also an obvious shot across the bow to others offering similar services to retail persons within the U.S.
So Zachary, as we discussed with Nick earlier, if this had been a situation where users could stake a portion of, let's say, their ETH and get a return that matched a variable rate based on whatever was going to be rewarded for staking, would it have been different, or would it have required them to directly have some sort of exact connection, if you will? In other words, that all that Kraken would have to do is be a facilitator rather than the entity that did the staking for them. Is there a way that this could have happened and they could have avoided that as a staking as a service, as providing that service, or is this sort of like, that's it? Even facilitating it is a problem?
No, well, I mean, the order doesn't get at the order. Again, the order is limited to what the facts surrounding Kraken's program. And to your point, if Kraken's staking as a service program was merely a technological connective tissue to an underlying protocol, that might have been a very different result. But instead, what Kraken appears to have done is essentially run a program on top of what the underlying protocol itself spits out. And so it provided assurances or guarantees or mitigated risks on behalf of their customers in a way that suggests reliance on them, separate and apart from what the underlying protocol itself, the risks inherent in the protocol. We're talking about risks inherent to a program built upon the protocol that Kraken was pitching to retail investors with reported returns, that weren't really tied to the underlying protocol itself, mitigating risks, allowing for mid-epoch withdrawals, and those types of things, I think, do suggest a potentially different result under say an investment contract analysis than you would if it was really just a connective tissue. An internet service provider allowing you to connect to the internet, not problematic. Where in between that and Kraken is the right mix? Stay tuned, I'd say, but at least now we have some guidance as to what we know the SEC would say is per se, at least from their perspective anyway, per se problematic.
Yeah, the SEC alleges Kraken sold unregistered investment contracts, and since staking customers are promised regular returns and payouts, we did hear from SEC Chair Gary Gensler talking about staking as a service from providers, in this video posted to Twitter after the announcement. Let's have a listen.
Here's the rub. When a company or platform offers you these kinds of returns, whether they call their services lending, earn, rewards, APY, or staking, that relationship should come with the protections of the federal securities laws. That means you, the investor, should receive important disclosures. For example, what do they actually do with your tokens? Are they really staking them? Are they lending, borrowing, or trading with them?
So is this consumer protection, or is it, according to some critics, just keeping retail investors away from investment opportunities that might be beneficial for the larger population?
Well, whether it's consumer protection or protection against commercial arrangements, I guess that's sort of an argument for the courts. What I would say is that certainly as it relates to Kraken's U.S.-based customers, there's no more risk. Of course, there's no more reward. So I don't know. I don't know if that's a net positive or net negative. I think I know how most folks in the crypto industry feel about it, but certainly moving those opportunities offshore doesn't benefit anyone in the U.S. At the same time, it doesn't really say anything with respect to existing staking as a service programs offered elsewhere. But I do think, as I said before, there is more guidance as to how folks can navigate these issues. And in that sense, there's something there. Right? It's not the ideal way you'd get it, right? But there is something to be gleaned from the facts of the Kraken case.
Correct me if I'm wrong, but it sounds almost as if Gensler, in all of this, he kind of gives off the impression that maybe he's okay with peer-to-peer lending and peer-to-peer stake and staking for individual retail investors, just doing staking as they would on the ETH blockchain as they would as if they were a large institution doing it, as long as it's the individual doing it themselves, and likewise borrowing and lending one to another. And it seems almost as if he's hardcore, like an old school hardcore crypto guy, like not liking the centralized exchanges getting involved in it. Is that what I know that's counterintuitive and definitely not the narrative going around, but it almost, after watching that, that's the kind of impression I got. Is that the kind of impression you got here?
Well, there's two things. One is what you're seeing is the SEC's increasing focus on intermediaries in the space. That is, people between the coins and the network. Whether that is a service being provided on top of, in between the protocol and its customers and its participants, or potentially, as you said, centralized exchanges. And maybe some of those are doing both activities. But the interactions of the actions of intermediaries has always been a huge focus of the securities laws. That's why we have the Securities Exchange Act of 1934. It is all about regulating intermediaries, and in addition to, say, investment company and investment advisor type rules and regulations. I do think peer-to-peer is not necessarily problematic, because it's not necessarily even the securities laws don't necessarily even cover that, other than straight up anti-fraud and some various provisions. So the fact that he may appear to be okay with peer-to-peer is that's great, but it's also sort of kind of the law. There's no requirement, for example, to use a broker to transact in securities. That's just the convenience, and sort of the cost of convenience is always well, what is this intermediary? How are they regulated, and how can you be relying on them, or what are their duties to you in the space? And so I think that's kind of where we get to, more comfort from peer-to-peer, less likely to happen. Like, I can take my securities to my neighbor, but they may not buy it. But if I have a broker, then I'm likely to find a buyer. But what's the broker's obligation to me? So you have a lot of these traditional securities laws questions keep coming up. Peer-to-peer, generally okay. If there's anyone between you and the ultimate money, what are their obligations? How are they interacting? What should you know about it? Whether that's an issuer of an investment contract or a regulated intermediary providing a meaningful service.
Well, speaking of intermediaries, they're speaking out. Coinbase CEO Brian Armstrong had just tweeted in part that it would be a terrible path for the U.S. if the SEC banned staking for retail investors. Could this lead to a wider crackdown in the industry?
It certainly could, but I don't know. At some point, there are diminished returns on the regulatory side by continuing to emphasize the same facts over and over. I think you've seen that over the years with the ICO crackdown. At some point, the SEC makes its points, and the rest is up to the private markets to sort of fall into compliance, or to frankly rely on different facts and circumstances to have a different result and to take a different position. And I think you see that a lot in the crypto space in particular, where the SEC relies on a facts and circumstances based test to assert its oversight. At the same time, sort of the downside of it doing that is that it's limited, and every particular action is limited to those facts and circumstances. And so to the extent that there are different facts, different circumstances, you might have a different result. And I think, so, other programs are not necessarily Kraken's program. And so they have their own legs to stand on and their own bases for reasons why they may or may not, why they may not be problematic. And now they have the benefit of this order, which highlights for everyone what the SEC is looking at and cares about. And so I think that having something to break against is really important.
Perspectives can also be subjective. I'll just also note that SEC Commissioner Hester Peirce shared her dissent yesterday to the SEC's crackdown. But we'll end it there. Zachary, thank you so much for joining us. That was Ketsal partner and former SEC Attorney Zachary Fallon.